Have you or anyone you know been injured by a government response to a pandemic crisis? Generally, a plaintiff seeking to recover on a cause of action for negligence must prove 3 elements: 1. Legal duty owed by one person to another, 2. Breach of that duty, and 3. Damages proximately caused by the breach. However, where a party is found to have been contributory negligent, recovery is barred as a matter of law, so, as the Bible says, you must do thy diligence. And, the elements of assumption of risk include: 1. Knowledge on the part of the injured party of a condition inconsistent with his safety, 2. Appreciation by the injured party of the danger of the condition, and 3. A deliberate and voluntary choice on the part of the injured party to expose his person to that danger in such a manner as to register assent on the continuance of the dangerous condition. Have you or anyone you know been injured by a government response to a pandemic crisis? Did you assume the risk, in contributory negligence, cutting off your nose to spite your face, as they say? Said one fictional, crime-solving sleuth, created from the imagination of Sir Arthur Conan Doyle, it is a mistake to confound strangeness with mystery, and the most commonplace crime is often the most mysterious because it presents no new or special features from which deductions may be drawn. Only a fool takes in all the lumber of every sort that he comes across, so that the knowledge which might be useful to him gets crowded out, or at best is jumbled up with a lot of other things, so that he has a difficulty in laying his hands upon it, while the skillful workman is very careful indeed as to what he takes into his brain attic, and he will have nothing but the tools which may help him in doing his work, but of these he has a large assortment, and all in the most perfect order. At least that was what Sherlock Holmes would do. But are you Sherlock Holmes? Or not? And, while many, especially post-pandemic, may balk at the suggestion of a conspiracy theory, suggesting that it must be indicative of cognitive impairment, or emotional problems, under the laws of Virginia, a conspiracy is a legal cause of action, and, as stated in Harris v. Commonwealth, decided by the state Supreme Court in 1912, a conspiracy must be a combination of 2 or more persons, by some concerted action, to accomplish some criminal or unlawful purpose, or to accomplish some purpose. Not in itself criminal or unlawful, by criminal or unlawful means, or do you still think that that is just crazy talk, the makings of a vexatious and frivolous case? In the matter, Worth v. Fire Company's Adjustment Bureau, the Virginia State Supreme Court took up that crazy topic again in 1933 to explain that a conspiracy consists of an unlawful combination of 2 or more persons to do that which is contrary to law, or to do that which is wrongful and harmful towards another person, and may be punished criminally by indictment, or civilly by an action on the case in the nature of conspiracy if damage has been occasioned to the person against whom it is directed. It may also consist of an unlawful combination to carry out an object not in itself unlawful by unlawful means. Or is that just more crazy talk, and the makings of another rambling prolix complaint replete with enigmatic allegations, mere criticisms, and repeating the same fantastical averments? Crazy as the case may be, in 1942, the Virginia State Supreme Court returned to the topic of crackpot conspiracies in the matter Gallup v. Sharp and determined that the gist of the civil action of conspiracy is the damage caused by the acts committed in pursuance of the formed conspiracy and not the mere combination of 2 or more persons to accomplish an unlawful purpose or use unlawful means. In other words, the basis of the action is the wrong which is done under the conspiracy and which results in damage to the plaintiff. No cause of action exists without the resulting injury, and the damage produced must arise as the effective result of the conspiracy. Or maybe you think that that is just crazy. Well, at least according to the rules of the Virginia Supreme Court, every person is competent to be a witness except as otherwise provided in other evidentiary principles, rules of court, Virginia statutes, or common law, and only the court may declare a person incompetent to testify if the court finds that the person does not have sufficient physical or mental capacity to testify truthfully, accurately, or understandably, and, as stated by the Supreme Court, in the infamous smallpox vaccine case, Jacobson v. Massachusetts, decided in 1905, the only competent evidence that could be presented to the court to prove these propositions was the testimony of experts, giving their opinions, and, in a statement regarding the rule of law, Justice John Marshall Harlan concluded that no power can be exerted to that end by the United States unless it be found in some express delegation of power or in some power to be properly implied therefrom. Still think that conspiracy theories are crazy? Are you an expert on mental competence or a court of competent jurisdiction? Probably not. Nonetheless, drafting the opinion for the majority of the Virginia State Supreme Court in a crazy conspiracy case in 2014, in the matter Dunlap v. Cotman Transmission Systems, LLC, Chief Justice Cynthia Kinzer had to consider the question as to whether a 2-year or 5-year statute of limitations applied to claims of tortious interference with contract and tortious interference with business expectancy, and, at the outset, she had determined that the viability of the business conspiracy claim turns on whether the tortious interference claims qualify as the requisite unlawful act, because the tortious interference claims are time-barred if subject to a 2-year statute of limitations. Post-pandemic and a 2-year closing of public schools to in-person instruction, particularly if you are a parent, custodian or guardian of a pupil in public schools, your question may likely be, what does that have to do with me? However, if you are a bit more familiar with jurisprudence, you would recognize that the cases raised on appeal most often are not entirely about the opposing sides, but more about the rules that apply in deciding matters for the lower courts. If an appellant prevails and is awarded a reversal of the prior decision for remand to the lower court, a rule that becomes binding on all later decisions, or, to use the legal term of art, establishing a precedent. And, in Dunlap v. Cotman Transmission Systems, LLC, Chief Justice Cynthia Kinzer concluded that an action for merely personal injuries is subject to a 2-year statute of limitations, while an action for injury to property and rights is subject to a 5-year statute of limitations. And, on March 13, 2020, with just report of 5 cases of COVID-19 in the county of Arlington, which had a population of 238,643, less than 45 cases in the entire state, and not yet one fatality, the Arlington Public School Board had announced the closure of public schools to in-person instruction, preceding even the order issued by Governor Ralph Northam, the only physician serving as a state governor during the pandemic, to begin lockdowns in the state, and it would not be until June 2020 that Governor Northam would issue any order to close public schools to in-person instruction, laying the entire responsibility on the local school boards, and their best judgment at that time.
This message was approved by Major Mike Webb. Honest.
And y'all go back now. Yeah.